Is Frank Nelson here?
Yeah, he's on Zoom with England. The ones that didn't want to go on the breakout room were turned off.
Okay, sounds good. On the record in the matter of Hamilton Road LTD versus Claude Miller, file number 23-01344 LT. Appears, please.
Morning, Your Honor. Gene Turnwald, on behalf of Hamilton Road Limited, our representative is here in my office of Hamilton Road.
Good morning, Your Honor. Darwin Fair on behalf of all the defendants in this matter.
Okay, today was the date that was set for a motion to set aside dismissal. This matter was dismissed. Sorry? What camera? Probably would help. Okay. Trying to find the file. This matter was dismissed on July 11th because plaintiffs failed to appear. Is there a motion to approve? I don't have one. Oh. I'm not really sure why it is that civil just put motions inside files, like I can see that before I get to the case. So this motion to reopen the case and rehearing was sitting on the file. I have not had an opportunity to review it. So Mr. Turnwald, you can make your case on the record.
Thank you, Your Honor. Before I get to the merits of the case, I'll do as you say. This is a motion to reopen.
I just want you to address your motion that you filed on the 14th.
Okay, that motion was to reopen. The case was dismissed by my personal failure to appear. I appeared at 2:25 p.m. The case was scheduled at 2 p.m. Inadvertently, my mistake, it was written down as 2:30 and it should have been 2 o'clock. The court was correct. A dismissal was entered. However, we had a contested motion. The case law and the statute is quite clear. If there's a contested motion, the remedy is not dismissal. I'd ask that the case be reopened and stayed. And then we're asking for a $1,600 a month escrow account to be opened to district court. And if the occupants of the premises at 2518 Pattengill sincerely want to remain there, they pay a monthly escrow amount. Otherwise, they're simply unjustly enriching themselves. The larger picture of what's going on is a circuit court quiet title action was filed. That action was not signed by any attorney, yet there are 4 parties to that action that claim to have filed it improper. We filed a motion to dismiss because the action is frivolous on its face. There's some serious deficiencies with it. The property at Pattengill was purchased at a sheriff's sale. 6 months went by. The redemption period ends 6 months from the date of the sale. If there's a dispute about it, the remedy is for the party in dispute to contact the Ingham County Register of Deeds, get the redemption amount calculated and deposit redemption funds. To this date, that's never been done. So we filed a motion to dismiss the circuit court case. Ironically, one of the parties to the circuit court case and the only named party in this case a person who identified herself on the phone as Betsy Miller contacted our office, wondered why she was getting legal papers, that she did not file the circuit court case, knows nothing of the district court case, believes the house has been long since foreclosed upon. And then opposing counsel is again here, apparently without any clients. So I'd like this matter dismissed, for open to and dismissed, and a writ issued in 10 days, because opposing counsel again has appeared for the second time with no clients. And yet the one named client, the estate of Claude Miller, the personal representative of who is Betsy Miller, has contacted our office and said she doesn't know anything about this case. And I have filed an affidavit from my secretary that reflects. At a minimum, Your Honor, we're asking the court to reopen the case, place a stay for the circuit court proceedings to continue on, and then asking for a $1,600 escrow amount. So the occupants, whoever they are, and they haven't identified themselves either, of this premises, don't unjustly enrich themselves and continue to occupy the premises while a frivolous circuit court case proceeds, or maybe it'll be dismissed in a month or two. I truly don't know until we have the hearing. Thank you.
Thank you. Mr. Fear, you can respond.
Well, Your Honor, counsel has made two arguments with regards to two motions. One is he's argued for a motion to reopen the case and for rehearing. And number two, he appears to be responding to the motion to dismiss for lack of jurisdiction. Now, I have had a chance to read both motions, and I would point out that there is really no law that they have cited which rebuts our motion to dismiss pursuant for lack of jurisdiction pursuant to MCR 2.116 summary disposition, C6. But you know, and our motion is real clear. It's concurrent jurisdiction, and the counsel is just really making our argument, because he's not arguing the case that's really before the court. He's arguing a circuit court case, and that should be taken up in the circuit court, which is the whole reason why this case should be dismissed while the circuit court makes a determination. And he can bring up all of his arguments that he wants in circuit court. That is where it should be, and not district court. The court dismissed the case, and quite frankly, from my standpoint, Judge, if he was here arguing his response, we would still have the same argument, and he has no case law, no court rule that rebuts our motion, which is fully briefed with case law, and makes clear that if there is a circuit court case that was filed before the district court case, it was filed before the district court case, then the district court case should defer to the circuit court case and be dismissed. Otherwise, Judge, we have the potential of inconsistent decisions, and the circuit court should be the one that makes a decision. Now, this whole issue of escrow, that presupposes that he's entitled to possession. But under our motion to dismiss, the case is dismissed. He's not entitled to possession, and he's not entitled to escrow. I'd ask the court to not set aside the dismissal, and let's wait to see what the circuit court has to say. If he wins in the circuit court, he wins in the circuit court. If he loses in the circuit court, he loses in the circuit court. But bottom line, it's up to the circuit court to make the decision, and he's asking you, Judge, to make a decision for the circuit court, and has no case law to support his position.
May I respond? That is absolutely not true. A complete misstatement of his own briefs. His own statute he cites, the own case law he cites, argues for a stay in these proceedings, not a dismissal. There is no case that says dismiss a district court possession case. We're asking for possession. We're not asking for title in district court. Therefore, it's not.
Okay. I agree, Mr. Turnwell. I was gonna say that you guys both asked for the same thing at this point. You both asked for a stay. Where are we at with the circuit court case again?
We filed a motion to dismiss against the 4 improper defendants. There's a hearing date. I'm off the top of my head, I'm not certain. I would estimate within a month. Excuse me, one more. What time? I believe it's in September. Sometime in September, the motion to dismiss in lieu of an answer. But in the meantime, what's really going on here are these unnamed occupants in the premises unjustly enriching themselves. And if for some reason the other parties in circuit court, these aren't even the same parties, if they win, they can get the escrow funds or they can refund the escrow funds. But right now, what's really going on is you have Mr. Fair filing this case on the exact same day the circuit court case was filed without attorneys, and asking for this case to be dismissed. In fact, it should be stayed, but I'd ask that an escrow fund being put in place. And again, I ask, where are your clients, Mr. Fair? The one important one, Betsy Miller, the personal representative of the estate, that she doesn't know anything about this.
Yeah, I would like to respond to this issue of stay versus dismissal. With regards to the clients, Judge, this is a non-issue that he's trying to bring before the court. But let me get,
Can you,
one at a time.
I am interested in knowing who are you representing particularly? Are you representing the estate?
Judge, I'm representing the occupants of the property. Paul Miller is deceased. And so
who are the occupants?
His wife.
Is that Betty Miller?
Betty Miller, his wife, and everyone else who is in this house. And I can look at the complaint because I did not file the complaint in circuit court, but those were the individuals who, yeah, who, but those are the.
And so, okay, and so can you address this affidavit that was from Mr. Turnwald's staff indicating that your client, who would be the personal representative and or at least the wife of the deceased, indicating that she has no idea or no clue about this proceeding?
Well, Judge, I can have my client do an affidavit, but I will say this to the court as an officer of court. I use a software that's called My Case, and Betty Miller, on a regular basis that I can document, goes into My Case to see the status of this district court case. So I don't know what counsel's talking about. But Betty, Judge, it's not in any type of context. And I have not shown this affidavit to Betty Miller. But again, I will say to the court that Betty Miller goes into my client portal. In fact, she went into it this morning with regards to this case.
She did what?
She went into my portal, Judge, to look at this case because this case is in the portal, and I can tell when someone goes to my portal, and she went to my portal this morning. So I don't know what this affidavit is about. I don't know it in context, and I have not given it to my client. And if the court wants, I can show it to my client, and I can do a affidavit based on my client's knowledge of the situation. So and Judge, people call. Well, yeah, but Judge,
I'm inclined to believe that you're not working for free. Someone's hired you.
Right. But Judge, I do want to address this issue about a stay versus a dismissal. This is a C6 dismissal, ground for dismissal, not a stay, a dismissal. And it's real clear. Any action has been initiated between the same parties involved in the same claim should be dismissed.
These are not the same parties.
You did argue for a stay though in your brief.
Well, no, that was an alternative, Judge. That was an
Oh.
alternative. But the main emphasis is Rule 216C6, a dismissal because there's another case. That is the crux. The stage is an alternative.
Okay, and both of the cases were filed the same day. Is that accurate?
No, I don't believe that was. I believe. Wait a minute. I can go look, but let's get this on the record. That my case was the circuit court case was filed before the district court case, and I am literally looking this up as we speak just to confirm that. And if Mr. Miller is going to state otherwise, I would love to hear that. The circuit court case. And I am literally looking it up as we speak. And Mr. Miller, Mr. Miller, you can also look because you should have.
Are you talking to Mr. Turnwall?
Turnwall, yeah, you should have it. I believe it was filed on June 20th. Now you would have a copy of that, so you can tell the court when that was filed. And we know when the district court was filed because it's before this court.
Yes, June 20th is the issue date on the summons.
June 20th is the issue date on the summons.
Right, and this case before this court was on the 21st, the day after.
No.
No.
Okay, all right, tell me something different. When was the district court case filed?
One moment, please.
I mean, I filed this case.
No, that's correct. This case was filed the next day and made reference in the document itself to the circuit court case, which is not signed by an attorney.
Well, Judge,
and the parties in the circuit court case are different than the occupants of the premises. They're not the same parties in interest. You have Innovative Properties, which signed a contract to purchase the same premises. Obviously, they believed Hamilton Road to be the owner. You have
Wait a minute, let me stop, because this was something you all, if you wanted to discuss this in private, you could do that. But my understanding is that you didn't. You said that the circuit court case was filed on June 20th.
That's correct.
Yes.
That's what he said.
Okay. Our summons, it looks like it was
May.
district court case looks like it was first. Let's see. Summons and complaint was filed in April, I believe, but it was served, and the parties were summoned to appear in court on June 21st.
Well, Judge, counsel just stated that in his motion, he made reference to the circuit court case. So, I mean, counsel has both cases.
I was talking about the document you filed, not the documents, not the complaint we filed.
All right.
Yeah, our date stamp here says the summons was received by the district court May 1st, 2023.
We filed for occupancy to remove the occupants out of the premises as they were not paying rent. And
that was when this eviction was initiated.
Yes.
It looks like the issue then became service. They were unable to serve or properly serve. Let's see. And so it was served by posting on June 13th at the property. Let's see, service. What is this? Something that's confusing here. Hamilton Road versus. What do you have a proof of service in the HRIS?
Post on June 13th.
June 13th. Okay, that's what I have as well. I see here Mr. Fair, where you filed a certificate of service of a answer to the complaint to Mr. Turnwald on June 21st in this file.
Okay, all right, Judge, I can't really speak to the circuit court case. It's not my case. I can speak to the district court. My understanding from Mr. Turnwald was that he made reference to the circuit court case. Judge, it is what it is. But the bottom line is still the same. If you have the district court and the circuit court, the district court shouldn't be making decisions that the circuit court ultimately must make a decision on. They're the circuit court. And so what counsel is trying to do is try the circuit court case in district court. And
That's not true at all.
This is what I'm going to do, because I've heard enough. I'm going to grant the motion to reinstate the case, and then the case will be stayed pending a ruling from the circuit court.
Escrow funds, Your Honor.
Your Honor, if the court is going to issue escrow, I don't believe escrow is necessary here. You have the house that is the bond on it. And if the court is going to issue any type of escrow, it should be an absolute nominal amount. And the court is not required to do escrow on a stay. They're only required to do escrow if there is a possession. There's no possession here. So if you want to stay it, that's fine, Judge. But the escrow, there shouldn't be escrow. And if you want to do escrow, it should be a nominal amount. And when I say nominal amount, I'm saying no more than $250.
We're asking for $1,600. It's the fair market value of the property. Even that is actually a little understated. The
But that
occupants,
Go
the
ahead. Go ahead.
occupants. and
Okay,
Betsy
you can
Miller-
file, Mr. Turnwald, please file a motion for escrow. Mr. Fair can respond to it. I'll make a ruling based on the motion and response.
Thank
All
you.
right. Thank you, Your Honor.
Thank you. You're all set.
Thank you.
Mr. Ingman and Frank Nelson.
Yes, Your Honor, present.
Okay. File number 23-00159. That's Citibank versus Frank Nelson. Counsel appearance.
Your Honor, Jonathan Engman appearing on behalf of the plaintiff, P 56364.
Today's date set for a motion for reissuance of order of eviction. Let's see.
Your Honor, this is just pursuant to court rule. Your Honor granted us a judgment for possession back, I think, in February. And we had a writ issued in March. And then, Your Honor, Mr. Nelson filed a motion to set aside the default, which was denied, but he was granted additional time. And so this motion simply states that we've passed the 56 days from the date that your writ in March was issued. And we're just asking for it to, for the writ to be reissued. I spoke with Mr. Nelson in a breakout room. He told me that he's got a few days left and he'll be out fully. So I'm not even sure there'll be an issue, but at this time, pursuant to the court rule, we can't do anything without a new writ.
Okay, Mr. Nelson, were you supposed to be off the property by the first?
Yes, ma'am.
Okay, and you're almost out of the property?
Yes, ma'am.
Okay. When are you gonna be out?
I could, within a week. I actually, honestly, I had to quit my job in order to get time to move.
Oh.
Plus, there was a payment that was, there was a $7,000 check that I was supposed to receive back. Payment that I made them, but they rejected it. And I talked to him, I haven't received it, but he said he's gonna look into it again today. I mean,
Why has he received his payment?
Your Honor, I have to look into that. I have communications with my client that his payments were returned. Those payments were made after the foreclosure sale, and so the client rejected them. But I will go back to the client and verify what's going on with it, and if they have tracking information as to whether it was mailed or not.
Okay, and if it was mailed, he hasn't received it, he needs a new check, he needs his money before I'm reissuing a new writ.
Okay,
So what I'll do is I'll reset this, and then that'll give you time to follow up with your client about whether or not payment was issued, and if it was, what happened to it, and how he's gonna get his payment and going forward. And then I'll address the writ at that time. Maybe he'll be out the property by then, but we'll see.
okay. Your Honor, are you setting a hearing today, or will we just get a new notice?
Yes, I'm gonna give you a date right now.
Okay.
August 9th. At what time? At 3 p.m.
Okay, thank you so much, Your Honor. I appreciate that.
No problem. Get you a copy of that date to appear, okay, sir?
Thank you very much.
You're welcome. You can have a seat. That's all we got on that one for today. I did that one.
What is that? Gonna be scheduled as? Same thing as today.
Thank you, Mr. Ingman.
Okay, thank you so much, Your Honor. Have a great day.
You too. Okay, I see. LVNV funding versus Shirley Lopez.
Good morning, Your Honor. Brian Gruen, GROEN, number 56673 on behalf of plaintiff LVNV funding.
Thank you. And Ms. Lopez is present. This is file number 23-01440GC. This was set for a pretrial. Did the parties complete a joint pretrial statement today or come to a resolution?
We'll probably just do a pretrial statement. Based on Mrs. Lopez's answer, we have submitted a hardship review to our client that's still being in the process of being reviewed. So depending on the outcome of that, it will kind of determine how we proceed with it, with this matter.
So you need a reset of today's date?
That'd be great.
How much time?
30 days.
Your Honor, may I speak?
Yes, ma'am.
With the information that I sent to the client and to LVN and to the court, and after talking to Legal Shield, I'm requesting that the whole case be dismissed. I got a letter from the client stating there was a glitch in their computer and they were supposed to correct it. They never corrected it. They sold it off to different collecting agencies till it got to LVN. And technically, I was told, now I'm not sure if this is what they told me at Legal Shield, they didn't have a right to sell this off until they actually got this situation corrected. They put my numbers on somebody else's name who was using the charge card to run up this bill. I never technically even got to make one charge. I tried, and the card I had was rejected. And when I contacted them, then they said they were going to get it corrected, and they never did. So I can't see why I'm going to trial, why I do need a hardship. I'm not going to deny that because I'm on Social Security. But the thing of it is, why in the world can't they go back to this initial letter stating that they made there was a glitch in their computer and they were supposed to correct it? Their correction was sending it off to a collection agency.
Okay, so Ms. Lopez, are you stating that this debt is not yours?
Yes, ma'am. They keep saying that it's my debt, but it's not.
Okay,
There's
did you submit that information in your answer?
Yes, ma'am, I did. I sent it to LVN. I sent it to the court system, the clerk of courts, and I sent it to the client because two things was going on. One, my bank account was being scammed And I've got a statement from my bank manager. I've got a statement from the police department and so forth. And then I've also got the letter from the initial client stating there was a glitch in the computer that made the error. So with all this going down, why can't it just be dismissed? I'm sorry,
Okay, so
I
you're-
just sound excited.
Your Honor, just to clarify, I believe Ms. Lopez is confusing this account with something. This does not pertain to a credit card. This was actually a loan and a promissory note is the basis of this lawsuit that was opened in
Well,
2018.
a lot of this started with the credit card thing that's when all the scamming came in play with the other. And it was all a total mess. That's why I had the police department report and the branch manager report that no money came to my bank account. And all this took place when the glitch in the computer on the credit card went through. I got the credit card portion taken care of, true, but the loan, the promissory note part, that never got resolved. It all got
Okay.
into a
Okay, so
quandary.
Ms. Lopez, you entered a agreement and signed a promissory note for a loan?
Well, that's what they claim, but I didn't. It wasn't, I didn't
You
get
did
the
not?
loan.
You
No,
say
there
you
was
did
no
not, so you did not
into my
sign a
bank
promissory
account.
note? You did not
My-
sign a promissory note?
No. I
Okay,
even
so
did,
you're saying
I
that-
even did
So you were
signatures for the.
saying you were a victim of fraud? Someone
I
else
am
signed
a
the note?
Yes, I am a
Okay,
victim of
so-
fraud. And
Okay,
I've
that's
got
all I'm trying to
to that
clarify.
effect.
So it sounds like you're disputing this claim. It sounds like you all do need to do a pretrial, and this matter does need to proceed to a trial.
Well, something of that nature, ma'am, because this is and it just gets to me because all this took place in one big mess with the credit card glitch in the one computer system that bounced over to the scammers getting into my system. I don't know. It's just such a total mess. It needs to be ironed out one way or another. And they even had me do signatures and my signature didn't match the note.
Okay,
The police
sounds-
department, investigated and found that there was others at that time getting into the situation that had been scammed.
Okay,
And my
okay,
bank
well,
even
this-
testified to the fact.
from what you're saying, I'm gonna stop you because this is not a trial. Today is a pretrial.
Okay.
So what it sounds like is that you're disputing this debt and so that means there's a question of fact. When I say question of fact, we now a trier of fact that's either a judge or a jury needs to determine whether or not what you're saying is true versus what the plaintiff is saying is true. The plaintiff says that you signed this promissory note, you owe the money. You're saying you didn't sign the promissory note, you don't owe the money. So we need a third party, that's a trier of fact, to determine who they believe, okay? So that is why
Okay.
the matter needs to go to a trial. So
Okay.
you would need to do a pre-trial, which is what today's date is for. I don't know if you intend to represent yourself. If you intend to represent yourself, you would need to have a knowledge of the court proceeding as it relates to civil process, because you would need to exchange discovery, possibly get information or provide information to the plaintiff as necessary, and then present the evidence to court at the time of your trial. You understand that?
Yes, ma'am.
Okay.
Can
You
I
said
have
that
an
you-
attorney? May
You
I get an
absolutely
attorney?
you can absolutely get an attorney.
Okay,
You would have to hire an attorney or see if legal services could provide you with some resources. You can contact them and do an intake and see if they can represent you, or you can contact the state bar to see if there's any other legal services or clinics that can assist you in this. You do not have a right to a court-appointed counsel in a civil matter. This is a civil matter, okay?
okay,
So I'll reset the pretrial, and that way, whatever was being processed, I guess, by Mr. Goins' client can still be processed, but then you can have time to seek counsel, okay?
Okay,
August 29th at 2:30. August 29th at 2:30.
And is Zoom permitted again at that hearing, Your Honor?
That is correct.
Good enough. I appreciate it.
Thank you. Do you have any questions today, Ms. Lopez?
I'm sorry, did you say 2 o'clock or 2:30?
2:30.
Thank you, ma'am.
Not a problem. Any additional matters for the record today, council?
That should cover it for today, Your Honor. I appreciate it.
Thank you, Ms. Lopez. Any other questions or matters today?
No, ma'am, thank you for listening to me.
No problem. You're all set. This was not on the topic for today, was it? Jackson it was. What's your name?
My name is Rakisha Jones.
Okay, not going to be for the same matters. Okay. You're Carrie Kemp?
Yes.
Okay. Is Kayla Saldana here?
No.
On the record in the matter of Carrie Kemp versus Kayla Saldana, file number 22-02156.
Your Honor, I made you a very organized.
Yeah, hold on.
Today was the date that was set for a bench trial. It was scheduled for 9 o'clock this morning. No one has appeared on behalf of Kayla Saldana. I do have Ms. Kemp present in person, and you were about to address something there.
Yes, if I may, Your Honor.
You may.
I made you a whole binder so you could follow along. You'd like it?
Well, we're not gonna have a trial because the other party is not here, so you just need to make a request for motion, or a motion, that is, for a default judgment, if you would like to at this time. Default judgment means you get what you're asking for by default because she didn't come.
Okay. And then I just file it out there?
Oh, you're gonna make the motion right now. Is that what you're motioning?
Yes.
Okay, your motion is granted. And what, I do have a note here. You were previously seeking $750 for the value of 2 chinchillas and 2 sugar gliders, and then what else?
So I actually found that I paid $750 for just the sugar gliders and $100 for the chinchillas.
Okay, $750
This is the
for
evidence
sugar
of that.
gliders. And then how much for the chinchillas?
They were $100.
How many chinchillas?
I had 2. Well, 3.
My note said there was 2 chinchillas, would have 1 passed, correct?
Yes. Yep.
Okay, that's what happened. And I think I noted here.
Oh man, I spent all my time organizing these numbers.
Chinchillas, something about a gift. Did she believe they were a gift? Is that what they were?
Mhm.
Oh, is that a yes?
Yes.
Thank you. Okay, 1 of the chinchillas passed away. Okay. I'm not sure why they passed away, and she's not here to attest to that. But you placed into her custody how many chinchillas?
3.
At $100 a piece? Was that what you
Yes.
say? And that's what you have? Can I see that?
If I may, Your Honor, I know how the chinchilla passed. If that's all right.
Okay, Musaka 250. What's
Oh,
that?
no. So Musaka is the names of the sugar gliders.
Oh, okay, and floating and peaches. Okay. Where's the amount? Do you have proof of the amount for the chinchillas? Or do you just remember paying? 100?
This was like back in 2019.
Okay,
And I remember because they were relatively cheap for that type of animal.
okay. You bought them all at the same time?
Yes.
It was 3 sugar gliders, correct?
Yes,
One was 250, one was 300, and then one was 200. Okay. So you're seeking judgment in the amount of $1,050
that's correct.
plus
Your
your
Honor.
filing fee.
75.
How did you serve her with the lawsuit?
You said what?
You served her yourself?
Yes, Your Honor.
Okay, you didn't use a process server.
I didn't know that I'd have to pay for all the processes, so no, I ended
Okay,
up,
yeah, it's fine. I just want to make sure if you paid for it, you get reimbursed, that's all. Okay. Oh, I told you did pay process servicer. George Lammers?
Huh?
Yeah, did you pay $45.64?
oh, yes, for the
Okay.
retrieval of my animals. Your Honor, she still has my chinchilla, because, the last hearing we had, so I know we're doing monetary compensation, but if that one her chinchilla is not, passed by now or sold, which I pretty
Well,
sure it
you're
is.
You sent someone to possess
Yes.
them?
Yeah,
You possess the animals?
yes, and she told the officer they died, and then when we went to pretrial, she told them that she sold them.
She said she doesn't have them, so there's nothing we can do.
Right.
3 sugar gliders were dead, 2 chinchillas were sold, and then she said one of the chinchillas passed away, correct?
Yes.
So there's nothing we can do about it. So we can give you a judgment and the amount that you sought in recovery or for that amount, which was for $750 for the sugar gliders, $300 for the chinchillas. You said a $75 filing fee
Yes, Your Honor.
plus $45.64 for service in your attempt to do a claim and delivery. Let's see.
Your Honor, may I ask a question?
Yes.
I know that Kayla Sedana is unemployed. How does that work?
Well, you're gonna get a judgment
Okay.
for the amount of $1,170.64. And then you have a couple of options. You can subpoena her here for a credit or debtor's examination to find out information about, you can return that to her, information about her finances, resources, assets, whatever, to see how you can get the money, or you can try to file for a garnishment with the court, go down to the clerk's office and you can request a writ of garnishment to try to garnish her wages and or tax returns.
Okay.
But you gotta get the judgment first. So judgment will enter in favor of plaintiff by default in the amount of $1,170.64. I will get a copy of the judgment for you in just a moment.
Thank you, Your
No problem. You can have a seat there. Favor of plaintiff by default, defendant failed to appear. Okay. You are Ms. Jones, correct? What's your name, sir? What's your name?
Nathan Wood.
Oh. Do you have a check for $700, ma'am? That's what this says here. Did you provide her with a $700 check?
I'm sorry.
Did you provide her with a $700 check?
At one point, yes.
Okay, what do you mean at one point? Did you take it back?
No,
Oh. How did you send it to her?
I'm sorry.
How did you give her the check?
Yeah.
Okay, did you receive the check?
Yes, I did.
Where's the check now?
I have no idea.
You received the check and lost it?
No, if I may.
Okay, let me call the case. You both can come up here.
I'm sorry. This property is a shady case.
I haven't asked you to speak yet. On the record, in the matter of Rakisha Jones versus Nathan Wood, file number 23-00151 SC. State your name for the record, ma'am.
Keisha Jones.
Rakisha Jones, and state your name, sir.
Nathan Wood.
Okay, so today's the date set for a small claims hearing. You all appeared before the magistrate on the small claims matter, correct?
Yes.
And it looks like the judgment for the small claims was that the defendant was to pay Ms. Jones in full for the amount of $1,203.84. And that this judgment will earn interest at a current statutory rate, correct?
Yes.
Yes, you may. Is that correct, what I just said?
Yes.
That's your understanding as well? You have to say yes or no for the record.
Yes.
Okay. Okay, so what's the issue today?
So to answer your question, I was in receipt of a letter with the check, and the letter said, and it was from Nathan, until you return all of my blinds you stole and restore my floor that you damaged back to how it was, I am going to withhold the rest of your money. I saw the check. I knew it wasn't for the full amount of my security deposit, and I tossed everything.
Okay, gotcha.
And I said that to
So
the
you
magistrate.
discarded the check.
Yes.
Okay, and so did you file an appeal?
Okay.
Well, just answer my question. You see I'm sitting up here? You know what that means? It means you have to answer my questions. You all don't get to run the show. I need to follow a certain procedure so I know what's going on. Did you file an appeal?
This is the big deal, yes.
Okay, that's yes or no. That's all I'm asking.
Yes.
Okay, and you don't believe you owe her back the amount that the magistrate said that you were required to return, correct?
Correct. She's
Okay.
suing the wrong entity.
Who is the correct entity you believe she should sue?
The LLC property. Here are the documents for the LLC.
I've not asked for any documents at this time. Did you rent property from him?
Yes, I did.
Okay.
also submitted electronic evidence
How did you submit electronic evidence?
to the 54A District Court. I emailed everything, the pictures, the audio,
To whom?
54A District.
Okay, that doesn't come to me. Did you bring your evidence and did you give him a copy of your evidence?
Well, the court, I emailed it to the court for the first hearing, June the 21st.
The hearing that you have before the magistrate?
Yeah,
Okay, well then, that, they don't just forward stuff on over to me just because you did that. That's not how it works. You could have, however, sent it to Judge Simmons' courtroom at lansingmi.gov, but let me see if we need all of that at this point. He's filing an appeal, and so you said she sued the wrong party. When she rented from you, what was on her lease agreement?
The LLC,
It was not your name personally?
I signed it, yes.
You signed it on behalf of the LLC?
I'm sorry.
You signed it on behalf, do you have a hearing issue, sir?
Yes, I do.
Do you need a device? We do have a device that could assist.
Well, I've got hearing aids in.
Okay,
I'm just hearing the wind, the noise from the,
we'll stop the fan. That's probably the fan giving you feedback. Is that better?
that's much better.
Excellent. Okay, so you signed, you signed the lease on behalf of the LLC.
Yes,
Okay. It's your belief that she should seek recovery from the LLC.
yes.
Okay, it's Rent to You LLC, the landlord, is that what you say?
Yeah.
Okay. Can you get a copy of this paperwork?
Just have them. They're online. There's 2 years there.
Yes.
May I please have the email address so that I can send you these documents?
I'm not necessarily sure I'm gonna rehash all the evidence of the dispute is that he's making is that he believes that the LLC should be liable and not him personally.
This is something new.
Sorry,
This is something new. This was not mentioned at all in the first meeting.
there was the fact that he had a LLC was not mentioned in the first hearing. Did you bring that up at the first hearing?
No, it was by video.
What does that mean that it was by video?
Well, it was through, like you had earlier.
But I don't care which mechanism you used to hold the hearing. I'm asking you, did you tell the magistrate that you believe that she's suing the wrong party?
No, that's why I object to the findings.
Oh, but you didn't object on the record as to,
I object to what you, what
You're-
your findings.
you're appealing her
Yes.
findings,
Yes.
but
And
you
I'm
never,
also-
while during the proceeding, stated she should be suing an LLC, because that's instrumental. That's what you're supposed to do if you think it was the wrong party.
Well, it came at I'm blindsided. I was blindsided by the fact that I was being sued at all.
Blindsided, you didn't know you were being sued until that day?
No,
Well, what does that, I don't know what that means, sir.
well, it means that I didn't understand everything.
But you knew you had a court date coming, correct?
Yes, and so I got things wrong with the court date today.
No, you knew you had a court date coming before you had your
Yes,
small claims
Yes.
hearing, okay. So you didn't just stumble into court one day and find out you were being sued. You were served in advance notice that you were being sued, correct?
that's correct.
Okay. So you had time to prepare. Let's see, what is this?
I had time to better prepare for this.
Yeah, well, you don't get to come back and appeal so that you can rehash things that you were supposed to do in the case. So you were supposed to make objections or put certain things on the record during the original case. And not wait until now that you get a judgment against you and then say, oh, well, she's suing the wrong person. That was the first thing you were supposed to put in your response to her lawsuit.
The magistrate said that when we came before you, we started all over again. So that's why I've got all the records.
You don't start all over again. You're appealing her decision. But your appeal is just based on the fact that you believe she sued the wrong person or the entity.
That's one part of it, yes.
Well, I asked you what was the basis of your appeal. You said she sued the wrong party. What's the other basis?
The other basis is that I think the magistrate failed to take into account the damage that the client left on the property.
Okay. And you brought evidence of the damage?
I did.
Okay, and you have your evidence? Okay, you can give her the email to send the evidence.
Courtroom email.
Excuse me, ma'am.
Yes, ma'am.
Will I have a time to speak?
You will, but no, that's not right now. It's his appeal. He wants to put some further evidence on that he didn't get to put in at the initial stage. We need to get your evidence. These are not good copies. I'm not understanding what's happening here.
Sir? You want this?
Does it look the same as this?
This color. Maybe a little clearer.
It just wasn't printed with a good printer, that's all. It's like the toner is off.
Well, those same forms you can get online. I mean, they do have them online. I print them offline.
It's not my responsibility to go online and get them. You're supposed to bring them to
No.
court.
I brought, so I brought.
But it looks like your toner was not good is the issue.
No.
Annual statement for 2022. I know, that's not gonna help it. That copy is distorted too. You have a copy of her lease? Who has a copy of the lease?
Have the cover of the lease.
Okay, when day was your lease signed?
Oh. When I first moved in,
That's the date you signed your lease?
so let me go back, it would have been in 2020.
You moved in 2020?
Yeah, it was during that time period.
Okay. Do you have any information that shows that this was a registered LLC in 2020?
Well, I didn't bring it with me, but no, I don't have it with me.
I do have a
But it's
copy.
been LLC for years.
You brought me 2022 and 2023.
I'm sorry.
You brought me 2022 and 2023 only.
Yes.
Well, you're saying she's suing the wrong party. Who I want to know, I need to know who she contracted with, and she contracted in 2020.
It's been. I mean, I can pull it up if you want me to pull up on the computer.
It's up to you. I don't want you to necessarily do anything. That's not my case. It's yours. Did we get her evidence? We'll have to get their documents together. Okay, back on the record, in the matter of Jones versus Wood. I went off the record to allow you all to gather and collect your exhibits that you intend to proceed with today. But first, I need to address the issue of the LLC. If you're indicating that she's suing the wrong person or entity, and that she should be suing the LLC, I need to first see, who did she pay her rent to?
Went directly into the LLC account.
She paid it electronically? Rent was paid, I'm sorry?
Yes,
Okay,
I've got a record with me.
you provide me the
I
record.
can find what's right here.
This is one of two. These not the same documents. This is saying one of two. Oh, the back is two of two. What is this? This is telling me the bank?
I'm sorry, I didn't figure it.
I'm sorry? No, you can't approach. What is this? You can't see it?
No, I can't see it clearly. Okay, just the top half applies. I wrote on something else on the bottom.
Okay, and then I don't see where there's a bank name on here.
Right, it's on
Just-
the first page.
Well, that doesn't go to this. This says one of two, two of two. This is a separate document.
It's the bank provided. So
I know this is bank provided. This is not part of that. What are you showing him? Yeah, but I want a thing at the top. And then, so how are you paying your rent to him?
I would physically go to the bank and pay how he instructed me to through the accounts that he owns.
The account to Rent to You LLC?
Yes.
Okay, and so, Rent to You LLC has a separate, funding account, and then I'm assuming, because you are showing me this form, although it's not the same as this other document, this does say Rent to You LLC. You received all your rents through that, because I don't see the name on the top of that paper. And these are not the same document. That's a 2-page document. The other page being on the back of
it's
that.
just a history of rent. What it is.
I recognize that, but I asked the question about you showing me
I
the
don't-
history of the rent and that it was paid to the LLC. So I'm wondering if you have proof that that document is at MSU
I do
FCU.
not have proof of that.
Okay, so you have a question?
I was trying to clear what you was just asking.
What is that?
So you probably see two different figures. So a portion. was
No,
paid-
I'm not worried about figures.
Oh, okay.
I was just worried about documents. I'm not worried about figures.
So I wanted to show this is where the money went to, Nathan Wood.
Okay, you have what is that you have?
This is a document from Lansing Housing. I also have a separate document where 2 large checks went to Nathan Wood, not Rent to You LLC, to pay my rent.
From Lansing Housing is what you're saying?
One was from Lansing Housing, the other one was through the care program.
Okay,
They
can
went,
you provide a copy of those? Let me see what you
Yes.
asked him.
all of my correspondence has been with Nathan Wood. I can show you various.
Right, I'm just right now
Okay.
talking about rent. I don't want to see correspondence, but who's the rent being paid to?
Yep, this is Nathan Wood. This is Nathan Wood. There she go. Mhm.
And I need a copy of the lease.
I emailed you, email.
This, you can give that, that doesn't tell me about any rent being paid in the name of Nathan Wood. I can go back. Okay, this is from rent, this is a rent change notice. It just shows me that they CC Nathan Wood. He's the registered agent, so they would CC him. Okay. Can, just to be clear, she can sue you and the LLC. You cannot represent the LLC in court. Do you know that? Is that a yes?
Yes,
Okay, so you're prepared to hire an attorney to represent the LLC in court?
if need be.
Okay, well, if I allow her to amend her complaint to add the LLC, you're gonna have to bring an attorney. Oh, is that, you're prepared, if that is the case?
Well, I don't know if the whole thing is worth all that much money, but. So I'm not prepared at this point to do that, but I'm prepared to explain the damages.
The damages that's owed?
Yes.
Okay, so I'll reserve my ruling at this point as to whether or not I'm going to allow her to proceed against the LLC. I'll let you go on with your other proofs as to the amount owed and damages. You paid a security deposit.
Yeah.
What was the amount?
1,200.
I'm sorry?
$1,200.
Security deposit. It was to be placed in escrow.
Yes, Your Honor.
You paid that security deposit when?
At the signing of the lease.
I need a date. I don't have a magic ball to know when that is.
I'm aware. I did email the lease. That's what I thought you were looking.
Yeah, but you gotta give me, I don't, you gotta put you're creating a record. And your record has to provide evidence. I can't put your evidence on the record for you.
So. June the 8th, 2020.
2020, June 8th. you paid $1,200 security deposit. And how did you pay the deposit? Electronically or check?
Money order.
Money order? Who was the money order made out to?
I'm gonna be honest, I don't know.
You don't remember? Okay. But you went to your bank, got a money order, provided it to Mr. Wood. Okay. Mr. Wood, you received the $1,200 money order for the security deposit, correct?
Correct.
Was it placed in escrow? Okay, where's the bank that it was escrowed at?
Commissioner Kristen,
Do you have a statement of that escrow?
no, I do not.
Can you provide a statement of the escrow? Why is that?
I just don't have one.
No, I mean, if, I know you don't have one today, I mean, at a later time, if I told you to send one, bring me one tomorrow, could you do that?
I don't think so.
Why is that?
Just went to the bank. I don't.
It just went in the bank in escrow, correct? Because a security deposit is supposed to be placed in escrow. You understand that? Is that a yes?
Yes.
I have to ask you that because the records, we can't do head nods,
I'm sorry,
shakes,
I'm sorry.
and uhs and ahs. So I have to ask if it's a yes or
That's
no.
okay.
Okay, so did you or did you not place that in escrow?
I do not believe that I placed it in a separate account.
Okay, you recognize though there's a reason why it's supposed to be placed in escrow, correct?
I do.
Okay, what is the reason that you believe it's supposed to be placed in escrow?
I don't know.
You say you did know, I thought.
Well, I do now, since you mentioned it, but I never thought of it before. I just put it in the bank.
It's supposed to be placed in escrow and accrued interest, and then the renter is
And I
entitled
gave-
to the interest.
And I gave her the interest.
How do you give her interest if it's not placed in an escrow account?
Because I estimated the interest.
Estimated it how?
I don't.
You received interest payments from him?
Absolutely not.
When did you give her, show me proof that you gave her interest
I don't have any proof. I have a copy of the check I sent her
for the interest?
for the deposit.
When did you provide her interest payments on her security deposit? No, you read it. Tell me the answer.
$1.50.
When?
This was on 2/7/23. I provided her a statement of the interest.
And when is the other times?
And Nick only did that one time.
Okay, so she paid you $1,200 June 2020 that was supposed to be placed in escrow. And almost 3 years later, the only payment that you estimated for her interest was for $1.50, correct?
Mhm.
Yes?
Yes.
Okay, thank you. Did you ever receive a $1.50?
No, ma'am, I
Okay.
did not.
Thank you.
I apologize. No, Your Honor.
It was with her.
Okay. If you say you gave her $1.50, it's really not germane because at this point, that's all you say you gave her. Whether she receives it or not, we'll deal with it later. Okay. Okay, so you paid escrow, then you vacated the property after some time, ma'am?
Yes, Your Honor.
Okay, when did you vacate?
The move out date was January the. That would have been January the 23rd, 2023.
23rd of this year, okay. And so you believe you were entitled to a return of your security deposit. Tell me what happened after that.
So after that, a few weeks later, I got a letter from Nathan. Well, can I talk about the walkthrough?
Okay, so you did do a walkthrough.
Yeah, so and I can play the audio of it. When I walked in, he was very confrontational and I brought a witness. And he's like, I already did the walkthrough. And I'm like, so you're saying you already did the walkthrough? And I was like, so then what do you need from me? And
So, okay, let me back up. So you moved out, you wanted to do a walkthrough with the landlord to show that you left the property in broom swept condition. Is that what you're saying?
yes, and
And so you arrived, are you inside the property at this
I'm
time?
inside the property. I brought a witness. So when we're at the door, I'm just standing there and he's like, where's the key? And I'm like, well,
You gotta do a walkthrough.
yeah. And so I was like, I thought you had a key, but I opened the door and I brought my witness because I have been harassed by him. And I needed someone there because I do not feel comfortable being in.
Nope,
Okay.
nope,
And so we're there. He's like, I already did the walkthrough. And I'm like, so you already did the walkthrough, you know, why, you know, I wasn't there yet. And so he's like, you can look at those papers. I'm looking at the papers. I'm like, what's this? And he was like, that's just the cover sheet. Don't worry about it. So then I started signing the stuff that I needed to sign. I knew he was getting started and you can hear it in the audio. He's confrontational. He's arguing. He called me a thief. He's creating a very hazardous type of environment for me to be there. So I'm trying to hurry up and get the paper signed so I can go. And so him and my witness start going back and forth. And then at that point, when they walk to the back room where he's shouting about a wall, I then tell her to come on, let's go. In the midst of that scene, I forgot to leave. I forgot to leave because I messaged him. I said, due to the hostile conditions that you made during the final walkthrough, I was unable to leave the final money orders. I said, I can come to your home with an escort or police escort and give them to you.
Final money orders for what?
Oh, just the final payment of the extra days I was there. He was charging me 46 something a day. And so either way.
You sent this via text message?
Yeah, I did.
And what does it say?
It says, due to the hostile conditions you made through the final walkthrough, I was unable to remain there and did not hand you the final pay money order. I can come to your home with an escort to give them to you. And then I called the police and I told them the situation. I told them how this man had been harassing me, how he been harassing my child, how he made the walkthrough hostile. And the police still wouldn't escort me there. So then I contact him and I said, unfortunately, the police will not escort me here. So I will send it certified through the mail.
Did he respond?
That will be fine. He said that will be fine.
Okay, did he respond to the other messages?
No.
Okay, just that'll be fine. Did you, and you sent them certified mail?
I did.
Okay.
And
then what happened?
Okay, and so I get that weeks later and I'm like, it's not my full amount. And then in this letter, he's repeating.
What did you get back? Oh, that was the $700?
Yeah, he repeated what he said at the walkthrough.
Well, you received $700 when?
I'd say it was 2.5 weeks later, maybe 3 weeks later. I received that letter.
Okay, so you didn't get the full 1,200 back, and then you received communication from him stating what?
Oh, on that letter, it was like, you stole my blinds until you return my blinds, until you return, my floor back to the condition that it was in, until you paint the white I wanted it. I painted the wall back white.
You have a copy of the letter?
No, I threw everything out. I literally threw everything out. That letter, that check, everything.
That's the letter. Okay, can you give me a copy of the letter?
And so he later.
Wait a minute. What's a rail hook?
I'm sorry.
I'm asking him, what's a rail hook?
I can give you a picture of it. It's we hang coats.
Okay.
Those are missing from the house.
May I see that letter?
Let me, just a moment, I'm gonna ask you to look at it. Okay, can you see if this was the letter she received? Just give me the whole packet. I read the first page. Was that the letter that you received from him?
No. No,
Okay, do you have a copy of the letter you received?
no, I threw that out with the check. When I got that, I threw everything out. I knew it wasn't the amount for the 1,200 security deposit. And I have been telling
But
this.
and you knew you intended to sue him for your full amount
Well,
at that time? You
not
know?
at that time. I wrote him in response to that. And I was like, because there was no mention of no real hooks. If I may play the walkthrough for you, there's no mention of it even in the.
We'll get there, but I first want to
Okay.
understand, why would you throw away evidence?
I didn't know, at the time, honestly, to be honest with you, I was so upset. He didn't return my $1,200. And I'm like, this is not what he owed me.
So that's not the itemization that you're referencing in your February 13 letter?
No, what he says is, until you return all the blinds that you took from me and restore my floor back how it was, you will not receive the remaining 500.
That's what that letter says.
Yeah, that's.
This says 696.50.
No, that said that it gave you a check for $696.50.
And it say missing rail hooks. That was not on there. That was not on there.
Okay.
There was no itemization of how much the floor cost. There was none of this. None of that was there. It was just a paragraph.
I know you probably didn't know this, but lawsuits are about evidence. I have to see evidence, and you don't have any.
I have the.
Not about you don't have your itemization. You were supposed to provide it. If you're gonna sue for a non-return of your security deposit, you need to provide me the itemization. This is what he said he signed on the 7th of February. You didn't provide me anything that shows me otherwise. Yes, sir.
On the back of that is a copy of the check, etc.
There is a copy of the check, but the check is for $700. It's not for $696.
No,
Thank you, ma'am.
I rounded it off because I felt it was fair.
Then he did not have that.
I don't want to go back and forth about it. Move on. Move on.
Okay, Your Honor. So in response to that letter that I got of him demanding these blinds that he say I took in the floor, he say I damaged, I responded back to him. I says, Nathan, I received your itemized claim as to why you are not returning my full 1,200 deposit last Friday, February the 10th, 2023 through regular mail. As I stated to you before, during the walkthrough, when you were yelling belligerently at me in the presence of my witness about the same illegitimate claims, like I said at that time, I paid for my blinds in full. I primed that wall back as you asked me to in my child room. And your floor got that greenish mark from it because of the many floods from your faulty pipes backing up from the laundry room. I says, you have been informed of the issues throughout my tenancy, which he has, and I show proof of it, sent countless plumbers to tell you the same thing because you refused to pay the money to get it demoed and repaired. Over time, it caused that to your linoleum. I says, you have no right to withhold my money. I dispute all your claims justifying this, and you have disrespected me so throughout this entire process, and I'm tired of the harassment, and he's harassed my child as well. I was originally in my original claim, I did ask for the return of my additional $500 times 2 based off of the law. And I
You said
did
you requested the additional return of the balance of $501.83.
times two. And I never cashed that $700 check because I threw it out. So I was requesting in full 1,700 plus an additional 1,500 for the harassment. And I can prove all the harassment.
Okay. I don't know if that was what the understanding of the magistrate was. I do see where she gave
The
judgment
magistrate would not hear.
Are you cutting me off while I'm talking?
sorry.
The magistrate put $1,100 plus cost of $103.83 and stated that there was a $700 check that was issued in January 2023. She did note that at the time she wrote this, which was June 21st, that check had not been cashed. I'm trying to see your original complaint, see what the 1,100 for the original request was for. Landlord Nathan Wood held $500. Times two. Okay, looks like she gave you that. That was under the impression that she had received a $700 check when you requested $500. But why would you sue or file a lawsuit? Looks like February 16th, so shortly thereafter, you filed a lawsuit for $500, but then you threw the rest of the check away.
You know, when I originally got that check, and I'll tell you, since February the 10th, that's when everything got tossed, as soon as I seen it. So I didn't throw it away after the fact. It was already thrown away.
I'm suing for $500 times two, which is state allowance. It says amount of money claimed 2,500. What is that? What does that mean?
So the amount of money that I was requesting for was the monies that he withheld times the state allowed two, and the $1,500 harassment that I have been enduring.
Okay, so you're asking for your deposit plus money for harassment, is what you're saying, pain and suffering essentially.
Correct.
Okay.
Yet I still do not have the full amount of 12. So basically it's 12 plus 500.
1,200 being the entire amount of your deposit, and you're asking for
an additional 500 because he withheld 500 of it. There was no basis for him to withhold it. He had no right.
Okay. And then you wanted to share some evidence as it relates to the walkthrough.
Yes. So for my protection, I was recording the walkthrough because I had been,
is that the video that you sent?
No.
What is this audio that was sent to me?
So I think that's us at the bank when I was trying to get my ledger and he was yelling at me at the bank too.
Okay.
He yells at me everywhere. My protection, I was recording the walkthrough because I had been.
That's Zoom playing, YouTube playing in the background. Interesting.
There was nowhere for me to park. Received Monday, 16th May 2022 at 8:15 a.m. There was nowhere for me to park yesterday. I'm getting my daughter ready for school.
Sir, where are you going?
I'm getting like.
Okay, well, you can't just get up in the middle of the court proceeding. You have to request a recess.
I have to eat here then. Because
No,
I don't want to get it.
you're not gonna eat here, but you can't just get up and walk out in the middle of the court. You gotta let us know what's going on, is what I'm
That's why
saying.
I was talking to him.
Well, you had already left before. He had to figure out where you were going. And you can't talk to him. You gotta let me know what's going on. Your Honor, I need a break. You can go and have a recess.
I need a break.
Thank you. You can take your stuff and go have your snack.
I'm getting up.
Okay, we ready to proceed?
Yes.
Yes, ma'am?
Your Honor, if I may speak.
Yeah, I asked, were you ready to proceed? Okay, you want to speak about what?
What we're about to hear and what led up to what we're seeing today. So this is the start of the harassment that followed after he decided he wanted to sell the property. I tried to present it in my claim. I was told by the magistrate that she would hear of no harassment. I couldn't even speak on the matter.
I'm not really interested in harassment either, to be honest with you. I'm not gonna give you a judgment for harassment. There's no possible way I can qualify that. I'll listen to that as it relates to,
I appreciate it.
yeah, you're here for a return of your deposit.
Yes.
We're not here for harassment, to be honest, and I know people sue for emotional distress and all that stuff, but it's very, very steep to climb an emotional distress claim. And what I'm assuming I'm gonna hear is him yelling at you. Is that what this is gonna show me?
A series of that. He's also wrote a letter involving my daughter. I really feel like
He wrote a letter to whom?
To me, but as if he was my daughter, my 8-year-old daughter.
He wrote a letter to you as if he was your daughter? I'm not following. Can you explain for me?
He wrote a letter. He says, Mr. Nathan, by now, you know my mom has time management issues and I am often the blame.
I'm sorry, he wrote a letter to you in the voice of your child?
I swear. Yes, ma'am.
Is that correct, sir?
He has been harassing us before.
Yes.
Why is that?
Listen to the letter and you'll know.
No, I don't want to listen. I want you to tell me why you did it.
I did it because she is a drama queen. And she's always blaming her poor daughter for things.
So you wrote a letter
yes.
to her?
Yes.
And pretended you were her daughter writing her the letter?
Yes.
That sounds like some harassment.
He has been outside my daughter's room.
Oh, that's
okay.
not.
Yes.
Okay, stop it. Stop it. Okay, back to the security deposit. If you want to sue for harassment, then you need to file a separate claim. I'm not going to address harassment today because I don't think, I think this, what you're saying here is likely inappropriate. I don't see how a grown man at his age should be sending a letter to his tenant pretending to be the tenant's 8-year-old child. It's grossly inappropriate, but I'll leave that to you if you want to file a suit for harassment and attach all of the things that you address in harassment. We're going to address the issue of the security deposit here. 45 days went by. Did you provide him with a forwarding address for your security deposit?
Yes.
Okay. Did you file a court proceeding for her for the claims that you make as it relates to alleged damages? That was a question for you.
I'm not sure.
Did you file a lawsuit against her for the damages that you claim she made to your property?
I did not file a lawsuit.
Okay, and so you have photos of these damages?
I do.
Okay, well, let me see your photos. No, you need to have them printed. I don't want to see your phone. I want to see printouts of the photos. You claim she took blinds, 9 pairs of blinds? I can't hear you.
Yes.
Okay. Ma'am, did you take his blinds? Okay.
No, Your Honor.
When you moved, would you move into another property? Did you do a walk? You want to play the video about the walkthrough, please? You can sleep it there.
Okay, so what you need now is the keys to my forwarding address. This is my security deposit too.
He says what?
Yes, your security deposit too.
Okay. Can you pause it? I need it to be closer to me because I can't hear his
I can't
response.
hear either.
And you can't email that video?
I tried. It won't do it.
Probably because of the size.
So you already did the walkthrough? Okay, so what you need now is the keys and recording address to send my security deposit to? Okay, what key?
That's like your security deposit too, yes.
What is this?
Well, it's just a cover sheet. Now we went through this list or thing. All the blinds are missing.
I paid for all of them.
No.
I bought all those blinds.
No, you did not.
Every single last one
You
of
did
them.
not buy any of the
I
blinds.
bought all of the blinds.
You did not buy
I
any of the
purchased
blinds.
every blind that came in here.
I'm charging for the blinds because the blinds were up here.
Why would you charge me for something that?
Don't you have pictures when you moved in that show the windows were bare? Okay, that's all you need.
You have pictures to show that when you moved in, the windows were
Every
bare?
last blind that was in here.
Took them down.
Can you pause that?
That's okay.
No,
Does the lease say that the blinds have to remain up?
there's no blind.
That's what I'm saying.
Pause the video. You say you sent me pictures
Yes.
of when you moved in?
You could see his truck still in the driveway. He was still working on the place. You don't see no furniture in there. No blinds are on the windows. I bought all those blinds. It's time, state, down, date.
Maybe we'll show your screen up here.
You said his truck is in the front?
Mhm.
What's his truck?
It's a white pickup truck.
Okay. I don't see that picture. I see a picture that has a work truck there, of utility.
No, there was
Okay.
another set that I sent. I thought you got them.
May I also see the picture?
I don't have them.
Oh, I thought you did.
So I show that they would.
We can resend it. I don't have that. We received the same email twice, it looks like, with the same pictures, but it's not that.
Okay, I remember him saying, is it the same email? But
And you said, sir, that the rail hooks is for, where you hang the coats? Is that what you said, sir?
Yes.
Okay, and you tried to charge her $55 for rail hooks?
Yes.
You have pictures that they were removed out the closet?
I have pictures of them where I where I bought them.
Well, I want to see where they were not in the property and when she vacated. And why didn't you do the walkthrough with her?
She wouldn't do the walkthrough.
That's not what that video, did she just play
She stayed
says?
in the kitchen. She wouldn't move.
No, that's not what that said. It said that you had already did it.
I walked through before she got there, yes.
So why did you perform the walkthrough without her?
Well, I was willing to go over the things and check them again, whether they're missing or not.
Right, you do understand that a walkthrough is required under a Michigan security deposit law, correct?
Yes, and that's what I was doing with her.
Well, why, that's not what her evidence suggests. Her evidence suggests that you told her you had already done it.
I got there early in the day. She would not sign the walkthrough.
I wouldn't either because you didn't do it with her. I wouldn't sign it either.
Well, I was willing to walk through and mark things and discuss it with her.
Why
Okay.
are these not going through? I see.
Okay, it's on your phone, but you can't send it?
I sent them. I don't know why they're not showing.
Show
to me.
him what's on your phone as it relates to the pictures of the property when you moved in. And no blinds. You show him.
I'm not gonna.
You'll have to hand your
remember.
phone. Just
Okay.
press it. Can you see that? Can't see.
Bigelow, you can bring the phone to him.
That's his truck. And then I can show the windows and no lines.
Slide.
Here's the next picture, all the rooms.
Okay, I just want to see show me the pictures you just showed him.
Okay.
Show me the picture.
Okay, but look at the top, the blinds up.
There's no blind here. What do you mean the blind is up?
It's at the top.
No, I see the portion where the blind should be in. There's nothing there. Looking at the properties from this picture, and it does show this picture was taken in June 2020. So that would have been when she moved in. There's no blind in this kitchen window.
Does she have all the windows or just those?
Is there another? Is there another? Is there another
Yes.
picture?
I've seen the front room and I've seen the kitchen.
Can you
turn that on silent?
This was
Oh, yeah, I'm sorry, I
confirmed,
meant to turn off.
and this was confirmed in the hearing before, and she stated the same thing to him as well. That's in the hallway leading to the other rooms.
Okay. Is there any other pictures of the windows?
Yes.
Okay, and there's no blinds. I think I've seen enough. I don't even need to see anymore. What did you have in your phone that you wanted to show me?
The stain. Floor. Which is about 9 feet from the laundry room. So it's the best, try to get the best picture. So. There's the stain floor. There's the laundry room. I showed it to her that day. So. There's a judgment there. I was able to clean it up. I couldn't figure out what it was. I invited her over to clean it up. She couldn't, she chose not to.
Okay, she addressed this in her response. Greenish mark on the floor is due to pipes. Floods due to your pipes being out of code and backed up into the back kitchen and laundry room. You have been informed about this issue throughout my tenancy there. Sent countless plumbers to tell you the same because you refused to pay the money to get the floor demolition and pipes redone. Over time, it caused the linoleum to change colors. She addresses that already. So I'm gonna give you that back. I'm ready to make my ruling. I find you, Mr. Wood, to be largely discredible, and let me tell you why. At the beginning of my hearing, first of all, I don't find you to be very forthcoming, but in the beginning of my hearing, when I asked you about what you did with her security deposit, you first told me that you escrowed it. Then you changed it and said, when I asked you, could you provide proof? You can't. I said, well, if I tell you to come back tomorrow and provide me proof, then the story changed to you didn't provide escrow at all. Now I don't believe what's coming out of your mouth because you started off by telling me some dishonest information. And so when I'm listening and I'm looking at the evidence that she's presenting to the court, you came up with some arbitrary amount about what you believe you owed her for interest. You are asking for some blind replacements where I'm looking at pictures, which her properties tell me when those pictures were taken. And those pictures were taken when she moved into the property. There were no blinds, but you're trying to charge her so $25 per room for blinds. I also heard evidence where she appeared for a walkthrough, which you, by the landlord, are required to do a walkthrough with her per the Michigan security deposit law. And you tell her that you've already done it and you just want her to sign some paperwork. And she's questioning you about, okay, I signed this and you're gonna, there's my forwarding address and you're gonna send me my deposit. And then you talk about some issues that you have, but you didn't do a walkthrough with her and you're the landlord. There's a difference between damages that you can deduct from a security deposit versus what's normal wear and tear. You happen to repaint a wall because she moved out, that's normal wear and tear. I don't want to hear about it. You happen to replace some minor damage to a floor that maybe she caused would be normal wear and tear. For example, if you had carpet and there was maybe a small or a couple of small spots on the carpet. As a landlord, that's the cost of business that you have. You gotta, when people move out, you replace and clean up the property and get it ready so you can put another tenant in there. You can't charge them for all the wear and tear and deduct it from their deposit. What you're showing me here now is some damage or some, it doesn't even appear to be damaged. It looks like it's discolored. And looking at the picture that you showed me of the linoleum, I have no reason to discredit what she stated to you in response to your letter about taking her money for that purpose. She said, this has been addressed multiple times. This is not because anything I did. That's why you can't wipe it off. This is because of something going on with a leak due to, or flooding due to your pipes and a code issue. I don't see where you address this and said, I don't have a code issue. I don't have a pipe issue. None of that was ever addressed. You just glazed right over that. Now, not only that, per the law, if you claim that there was damages done to your property, you had 45 days to file a suit against her. You didn't do that. The law said if you didn't file the suit within 45 days, and if she didn't provide you with a forwarding address, which she said she did, and I heard her talk about it on that video that she played, and if she's responded to all of your notices regarding damages within 7 days of getting it, your notice that you submitted to the court was for February 7th. I see she responded on the 13th addressing that. Then that means she gets double what her security deposit. Not double what she's seeking, but double her security deposit. So judgment in favor of Ms. Jones in the amount of $2,400. You can give them his paperwork back if I had it still. This one right here.
So are we finished?
We are done.
May I ask a question?
Yes, ma'am.
How do I file harassment about what you did concerning the move out?
You'll get you have to go down to civil and file a new complaint alleging in writing what your allegations are, and you'll serve him with your lawsuit as it relates to that, okay?
Here's your main.
You pass it over to me. I'm sorry, ma'am, you had court costs of $103.84. What is this amount?
Yeah, for
the filing fees that I have to pay to have them started.
Thank you.
So the judgment is what now?
It's 25.03 and 84 cents. We'll get you a copy of the judgment in just a moment.
Now I can file with the LLC, is that correct?
What about your LLC?
So I could file also with them.
I don't know what you're filing with your LLC. I said that she could amend to add the LLC. She could sue both you and the LLC. It's a limited liability corporation, so she can sue both of you. She'll sue you, and I'm gonna let her proceed that way.
You're done.
They both should be waiting for a copy of the judgment. Okay, yeah, he should wait too.
Can I wait in here?
You absolutely can.
Okay, no problem. I'm sorry.